So the Copyright Amendment Bill and the Performers Protection Amendment Bill have finally been passed. These bills are expected to change the economic fortunes of many artists in the country. The pieces of legislation have become a bone of contention, with some in the industry saying that they should be sent back to the drawing board as they'll impoverish copyright owners. However, Arts and Culture Minister Nathi Mthethwa believes that the bills will benefit creatives, especially when it comes to remuneration. Let's unpack an aspect of the story, bring in blind SA CEO Jace Nair, who joins us via our video link this morning. And Jace, it's great to have you on the program. Thank you so much indeed for speaking to us. Your interest as Blind SA, of course, is more in relation to the Copyright Amendment Bill. I think it was just a few months ago, last year sometime, when the Constitutional Court was hearing a case involving you and the Trade and Industry Minister, I beg your pardon, around essentially declaring parts of the Copyright Act unconstitutional because it didn't give provisions that allow for certain documents to be reproduced without getting the permission from copyright owners. It's a lot to take in, so perhaps let me allow you to paint that context as I ask the question about whether or not you're happy with the form that these bills have been passed in.
Thank you very much for this opportunity. Yes, the current Copyright Act of 1978 did not provide any exceptions and limitations that will allow blind and partially sighted persons to transcribe copyrighted works into accessible formats such as Braille, large print, and DAISY audio, so that we can navigate through the book and be able to use it to gain information and to gain knowledge and to gain educational opportunities. Eventually, in September last year, we took the matter to the High Court in Gauteng, and the High Court provided an award saying that the 1978 Copyright Act is indeed unconstitutional, and the Constitutional Court therefore had to look at the unconstitutionality and to provide possible solutions. That took place in May this year, on the 12th of May, and the impression we got from the judges that looked at the case is that certainly the situation in terms of blind and partially sighted persons' rights being violated was indeed so, and they also sought the need for some urgent interventions to take place. We are expecting the Constitutional Court to provide their judgment by October this year. In the meantime, the National Assembly, the Portfolio Committee, has been looking at the reservations highlighted by the President and looked at various aspects of that. Firstly, in terms of Section 19D, that specifically provides for persons with disability. The basis of the Marrakesh Treaty are contained in Section 19D, and the revised provision now would also provide for cross-border exchange of books, is now included in 19D. And from Blind SA, we are very pleased at this development, that the National Assembly passing this bill. The process in terms of other areas, in terms of the creators, in terms of artists, in terms of authors, their situation has also been improved. The old Act limited their right to earnings, particularly in terms of their appearance, the need for them to enter into more reasonable contracts, and to allow this sector of the creative industry to also look at labor issues in terms of unionization and so forth, so that they could have a better stake in the income that their works generate.
Sure.
So from that perspective, I think, blind and partially sighted authors, performers are also affected. So we are very grateful and support that.
Jace,
The
if I can come in there.
now, yes.
Apologies for interrupting you there. I just want to take a few steps back. This section 19D that you've spoken about, I think the president at the time ordered that it be immediately read into law. I presume that's happened. What are the implications? Does that mean that blind and visually impaired persons are now able to reproduce this work that we were speaking about without seeking the permission of copyright owners, which would be a major thing if that is the case?
Yes, it has not yet been implemented. We're waiting for the Constitutional Court to pronounce on that. And once they do, then that would make it much easier for conversion into Braille. However, I think the Constitutional Court is looking at how do they give effect to that without interfering with the process of the legislature.
Right, because that was going to be my next question. There are two parallel processes that are running. The National Assembly is having its own discussions, while the Constitutional Court itself may very well deliver a judgment that undoes the work of the National Assembly. How worried are you of that kind of conflict?
I don't think we are very worried in terms of that, because Section 19D was not contested by any person or any other party or company. I think it was generally accepted that blind people's rights have been violated for many, many decades. The vehicle to make that more accessible, I think, is what people were trying to find out. Our concern is that this process, now that it goes to the provincial legislature, may take a long time before the 9 provinces have deliberated on it and it comes back to the NCOP. So that time delay is what is of concern to all of us, because for over 40 years with the current Act, we've not had access, and this delay will further impinge on our rights. So I think the Constitutional Court is looking at how best they would be able to address both those issues without creating a legislative challenge that could occur.
Sure. Jace, thanks very much indeed for helping us understand this better. All the best. Hopefully the process is wrapped up rather sooner than later, especially when you consider what's at stake. Jace Nair is the CEO of Blind SA. Once again, thanks very much indeed for your time.